Hello, wonderful people, great people. How are you doing? Hope you're good. Hope you're fine. How is life? Hope you're good and hope you're taking it easy. Welcome to this beautiful and wonderful channel. Thank you for always stopping by to see what's new on the channel. Thank you for my returning subscribers, always coming by, stopping by, checking what is new. I appreciate you. And for you who is new to this channel, thank you for checking us up. If you've not subscribed, please hit the subscribe button and share this video. So today we're looking at the innovations in the new Court of Appeal rules of 2021. A lot of people have heard about the new rules, but they've not had reasons, or they've not had time to sit down to look at the rules and see what is new, what was added, and all of that. So today we're going to just look at it briefly. I know you learn one or two things from what I'm going to say, on what I'm going to teach, or what I'm going to the exposition. The old rules was the 2016 rules. Now, on the first day of November 2021, these new rules came into force. And it's a wonderful one. We've gone through it. You see that there are a lot of innovations to help, you know, quick dispensation of cases, having in mind that technology has come to stay, and the coronavirus pandemic also changed the narrative in that um, the world was brought to a halt. So people had to find ways or means to keep going, even if we had we'll have to return to a place of lockdown and all of that. So these new rules, incorporated, all those issues, and I must say, it was not a day's job. The drafters of this law, of these rules, they really tried. I must give it to them. Now, a quick one, let's go into it. I must also say that the new rules, if you don't have it, please try and buy it. It's something that should be in every lawyer's library. It should be part of what you should use to, pride yourself. Yes, you must know what is happening. It must be updated. Don't wait for people to tell you. Look at it, buy it, read it, go through it and be familiar with it so that you can be updated with the appellate practice. One of the innovations or the new things that was added to the new rules is virtual hearing. The rules made provisions for virtual hearing. Yes, virtual hearing. Yeah, so that you can sit in the comfort of your office, in the comfort of your home. Yes. So, other 21 of the rules made provisions for this. So I'm going to read other 21 for you. Though I may not have time to read everything, but this very provision is very, 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 very important, because that is the stage we are in the world. We have gone virtual. So other 21 is about virtual hearing. They say the court may conduct its proceedings virtually where it deems fit. It's a subtle, define what virtual hearing means, you know, and I must state that um, the provisions here is aligns with the realities of the times we are in now. So other 21 talks about virtual hearing, and the fact that the link to the virtual hearing can be given out so that the public will join, or will look at, or will participate in the proceedings. Also, in as much as we now have the virtual hearing, all that, it doesn't mean that one can now wear anything to you know utilize this new innovation. No, it still maintains that the etiquette, the dressing, the mode, and all that you require that has been observed in the physical sitting should be observed in the virtual sitting. So all practice of decorum etiquette during physical hearing shall be observed. Now the president has that power to periodically issue directions, for the regulation of the virtual hearing. Now, under 23 of the new rules, makes provision that judgments may also be pronounced virtually. This is very important. Judgments can be pronounced virtually. You connect to the platform, whichever platform you use, your clients connect, and judgment is being read. So it's a very great innovation, I must say. Now, Order 20 of the new rules, it makes provision for electronic filing. Electronic filing, this is very important. You can stay in the comfort of your office, comfort of your home, to prepare your process and file it electronically. The challenges we face when people go to file physically, it will be reduced, especially in the times that we are in, where people are not advised to be in a club where, crowd, where there's crowd. People are advised to, don't always go to where there's crowd, or even if you're there, wear your mask and all of that. So in the comfort of your office, can file your processes. So I'm going to look at Order 20. I'll read it out for you, even though you are, this is just like a sniper. When you get your rules, you read it very well. So Order 20 talks about electronic filing. So there shall be established a 24-hour electronic filing system. That means you can even file at night. You can file anytime, 24 hours in the registry of the court, and it shall be functional in all the judicial division. This electronic filing and the virtual hearing, they complement each other. And this also goes to show that there is need for stable network, stable internet service, because you can't do these things where your internet is not stable. Now, and the on other sub two says this electronic filing unit will be established in each registry of every division. You know. Now, one very thing I noted in under Order 20 Rule Sub 3 is that where the process is filed through the filing portal of the electronic filing system and is after 2 p.m. on any working day. That means when you're filing electronically and is it's past 2 p.m., it will be deemed that you filed the next day. This is very key. As much as it is a 24-hour electronic filing system, but once you file after 2 p.m., it is deemed that you filed the next day. Yeah, so this is just one of if you read it, you will understand, but these are just few the salient features of that order. Now we look at Order 20 Sub 8. Order 20 Sub 8 talks about electronic signature, because you're going to file electronically, so you should have electronic signature, which you affix, or which you place on the signature part of the process. So Order 20 Sub 8 talks about electronic signature. Then Order 20 Sub 6 talks about that the registrar that is in charge of the electronic filing unit shall electronically seal and date every document filed through the electronic filing system. The issue of sealing, very important in the process, in the filing, sealing, dating, and all of that. So the registrar in charge of that unit will be able to do that electronically. Yeah. Now we're going to look at Order 8 Rule 3. This is another innovation, Order 8 Rule 3, where we talk about electronic compilation and transmission of records of appeal. At the beginning part, or let's say when you want to appeal a matter, you have to compile records of what happened at the lower court, which will be transmitted to the Court of Appeal. Now it's saying that Order 8 Sub 3 makes provision that you can compile and transmit your records electronically. This is a very beautiful uh, um, provision. Is innovative, is beautiful, is nice, and it will aid the appellate process and all of that. So it's saying that, let me read that sub 3. It said, whether any party attend or this time I'm talking about settlement first. Like when the registrar calls for settlement of documents of between parties. So whether any of the parties attend or not, provided that the notice has been duly served on the parties to the appeal, the registrar of the lower court shall proceed to prepare the record of appeal by settling and determining the matters stated in Rule 2 Sub A and B of this order, encrypt and transmit the record of appeal electronically to the official electronic email address of the registry of the judicial division of the appeal where the appeal court or where the appeal is to be entered. That means the registrar of the court who is doing the compilation of the can transmit the records of appeal to the registry of the court of appeal, depending on the judicial division. But provided beyond transmitting it, you have to know that beyond transmitting it electronically, 10 physical copies of the record will have to be transmitted to the court. As soon as you've done the electronic part, 10 copies of your record have to be transmitted to the court. So look at electronics. Another innovation is the electronic service of notice of appeal. Look at Order 2. Order 2 of the new rules makes provision for electronic service of the notices of appeal. Said by Order 2, sub 1 says every notice of appeal shall, subject to the provisions of Rule 2, sub 8, be served on the respondent personally or by electronic mail to the electronic email address of the respondent. Makes provision for service of notices of appeal. Now, let's look at this Order 2, sub 1, the B, sub B, Order 2, Rule 1, sub B. Say, except as may be provided in this rule or any other written law, it shall not be mandatory for notices, orders, summons, warrants, or other processes of the court to be served personally. What he's trying to say is that once these processes have been served, even court processes have been served electronically, it need not be served personally. This issue of service, it will save a whole lot of problems. Where we're talking about the charlatans in the practice, people that will extort you for service, the sheriffs and all of that. Some of them are doing well, but some are still, greedy and they want to extort you. So this, once you pay the specific amount of money as stated in the portal, your process is served with a process is served. So it's so this sub B is very important. Say that after you serve electronic, you need not serve it again personally. It's a very good innovation. So we're going to look at another innovation, which is Order 3 Rule 12. Order 3 Rule 12 is talking about the fact that the course list for the week, for the month will be uploaded on the website of the court, beyond pasting it on the official billboard. So you see, Order 12 sub 1 says the registrar shall publish every Friday a weekly course list on the official notice board in the judicial divisions of the court and on the official website of the court. That means you can as well check out the course list every Friday on the court's official website, to see your fixtures and all of that. This is very important. Now, another very important innovation in the new rules is the fact that every application must be accompanied with a written address. Yeah, you're filing a motion, must be ready to file a written address. Under the old rules, you don't file a written address with your application, your motion, and all of that, unless directed by the court, where it's like a contentious issue, a contentious matter. They'll say, counsel, okay, let parties file a written address to expound or to expatiate their argument. But now, it is a mandatory feature. It is a mandatory feature, and your written address should not exceed 5 pages. So that is in Order 6, very important, very, very important. Order 6, you must file a written address to your applications. And now, when you file it with a written address, you have affidavit, of course. The respondent shall have 5 days to respond, and you now have 3 days to file a reply, and that your written address shall not exceed 5 pages. And it specifies, the fact that your written address will help expound or expatiate what your argument is all about. Now, another very important feature is the payment of a deposit, monetary deposit by the appellant. That means, see, this innovation is important, it's good, but some people will say, okay, what if I don't have? You have to prove you are indigent. That is Order 8 Rule 11. Order 8 Rule 11 says, upon transmission, once that the records have been transmitted, whether by the registrar or by the appellant, the appellant shall, within such time as the registrar of court shall direct, deposit not less than 50,000. So your appellant, your filing an appeal, be ready to deposit not less than 50,000 naira with the deputy chief registrar of that division for the due prosecution. Remember, look at the essence of the deposit you're making for the due prosecution of the appeal and for the payment of any cost which may be ordered to be paid by the appellant. Remember that there's a proviso that says that provided that no deposit shall be required from an indigent person. That means if you are claiming that you're an indigent person, you have to prove that you're indigent. I don't know how you prove it after your affidavit of an affidavit to say you're an indigent person. So, but if you're an indigent person, they won't collect that money from you. But if not, you're supposed to pay, or when a deposit will be paid by the federal government or the agencies of it, they don't need to pay. These are the two people, set of people that will not pay: indigent persons and the government or the agencies. You know, and remember that this money they can request for more where the sum deposited in accordance with this sum is depleted in the course of prosecution or appeal, the registrar shall summon you to replenish the deposits. So I know a lot of lawyers might kick against it, but some people it's important. Now the question now will be: if I pay this money, will it cover service? Will it cover all this other incident? Small money here and there, or what is the prosecution all about? So these are questions I'm begging for answers. These are some things people will ask. If I pay this 50,000, but they say it's for the prosecution of the appeal, you know. So and if he finishes, the registrar can summon you to replenish so that there will not be a depletion. you know. So it's been an amazing. I will do a part two of this topic because I'm not exhausted. It's there are lot of things that were added in the 2021 rules. So far we've been able to do some, and I hope you learned something. I hope you learned something. Another thing I want to talk about is that under the new rules we have the I'll call it the Court of Appeal Alternative Dispute Resolution Center, called the CAADRC. CAADRC, Court of Appeal Alternative Dispute Resolution Center, where the parties can come, the parties cannot, appeals can be referred there for resolution. We also have the Court of Appeal Alternative Dispute Resolution Program. That's a program. If you can choose to go through that program, or the court can mandate parties to go through that program to see if their appeal or their matter or their issues can be resolved. So we have the CAADRC, we also have the CAADRP. One is the center, and the other one is a program. So you do the program in the center. So parties can choose to do that. The court can also order parties to do that. So we've been able to talk about the few changes and innovations that are prevalent, how we have seen it in the Court of Appeal rules of 2021. I'm going to do a part two of this topic to discuss the other innovations. So stay blessed, stay well, and know that you can always be the best you can ever be, and there's no you're different. You can always exceed your expectations. Please, if you've not subscribed to this channel, hit that subscribe button, share this video, like this video, drop your comments. Let me see what you're thinking. Let me just hear your thoughts on these new rules. Do take care of yourself.